All right. Well, glad we could get you here, Mr. Crane. We had set it up with Andrew County, and then they um, shipped you without ever telling us.
Yeah, that's what I heard.
All right. Let's call a case. We'll be on the record in case number 2020-CR133, captioned State of Kansas versus Jeffrey Ryan Crane. Would the parties announce their appearances, please?
May it please the court, the state appears by and through Thomas Penland.
May it please the court, the defendant appears in person and with counsel David Pachacon.
All right, we're set down for a plea today. Sir, to take up your plea, I'm going to need to ask you a lot of questions. First things first, though, I need to have you sworn in. So if you'd raise your right hand, my court reporter will swear you in.
You solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you.
You're welcome.
All right. Now, if I ask you something and you don't understand what I'm trying to ask you, tell me that so you and I can talk about it, make sure we're on the same page before you give me an answer.
Yes, sir.
If at any time you want to talk to Mr. Pachacon before you answer a question, you just tell me that. I have the ability to send you guys to what's called a breakout room where you can talk with him without us being there. Okay?
Yes, sir.
All right. How far did you go in school, Mr. Crane?
I went to 11th grade. I dropped out. I meant to get my GED. I never did.
All right. You read and write okay?
Yeah.
All right. As you sit here today, are you under the influence of any alcohol or drugs or prescription medicine that might keep you from understanding what we're doing today?
Absolutely not. I'm sober and level-minded.
Okay, sounds good. You know what you're charged with?
Yes, sir.
You know you don't have to change your plea of not guilty to guilty. If you wanted to maintain your not guilty plea, you would have a right to a jury trial on these charges. Do you understand that?
Yes, sir. I understand.
At that trial, Mr. Pachacon will get to help you out. He would confront and cross-examine all of the state's witnesses. He could call any witnesses you wanted to come. If they didn't want to come to court, he could use the subpoena power of the court to make them come. You would have the opportunity to testify at that trial if you wanted to. But if you didn't want to try to testify, you would have a right not to testify. And if that's what you decided, the state couldn't use that to try and argue that you must be guilty. You understand all that?
Yes, sir. I do.
All right. If we went through that trial and at the end of the trial, you were found guilty, you would have a right to appeal that conviction to an appellate court. And if you didn't have the money for that appeal, a lawyer would be appointed to do it for you. Do you understand that?
Yes, sir. I do.
All right. Now, if we go forward with this plea today, you're going to be giving up all of those rights. There's not going to be any kind of jury trial or trial to a court. You understand that?
Yes, sir.
All right. So your attorney provided me with a copy of the plea petition. I'm going to show it to you here now. Let me know if you can see this. Can you see that document?
Yes, sir.
All right. You recognize that?
Yes, sir.
All right. Is that the plea petition that Mr. Pachacon went over with you?
It seems to be. Yes, sir.
All right. When you went through that, did you feel like you understood everything that was in it? Mr. Pachacon was able to answer any questions you might have?
Yeah, I feel I did, and I feel he was very good in answering any questions I had.
All right. So I see in here, it talks about the plea deal that's been reached between the parties.
Yes, sir.
It says that you're going to plead to the amended count 1, which is possession of hydrocodone, which is a severity level 5 felony, and count 2, domestic battery, a B misdemeanor. They're going to agree to recommend to the court an aggravated term in whatever box you fall in for the felony and 6 months in jail for the misdemeanor. And that they're going to jointly request that these sentences run concurrently. Is that your understanding of the entire plea, Mr. Crane?
That is, yes, sir.
Anybody promised you anything other than what I just read to you to get you to plead guilty today?
No, sir.
Anyone place any force or threats against you to make you plead guilty today?
No, sir.
All right. Now, do the parties have a belief what the defendant's criminal history is going to be?
Judge, I think he's an H.
That's our belief as well.
Okay, so basically H is one more than the very least criminal history you could have. Means you have just misdemeanors on your record. You understand that when you talked to Mr. Patricon, you told him about that history and he looked into it. He's probably predicted what kind of sentence you're going to get based on that. But you understand that until a pre-sentence investigation comes back and tells me exactly what your criminal history is, if it turns out that there's something that the lawyers didn't find or you didn't tell them about, that could make the sentence worse than you would think that it might be. Do you understand that?
Yes, sir.
All right. Now, what I have to do for today's purposes is assume that you have the very worst possible criminal history so that I can advise you of what the maximum that anyone can get for these crimes is, okay?
Yes, sir.
It says here that the most anyone can get would be a prison sentence of 48 months. And what I think that is the 42 months on the felony plus the 6 months on in the jail, and a fine of up to $101,000, that being $100,000 on the felony and $1,000 on the misdemeanor.
Okay.
You understand those are the maximum penalties anybody could get,
Yes, sir, I do.
and it would carry a 12-month post-release if you were to get one of those sentences. You understand that?
Yes, sir, I do.
Okay. So any questions about any of this that we went over so far today?
Not that I have right now, no, sir.
Okay. And I see there's a signature that I've scrolled down to there where it says defendant. Is that your signature on that document?
Yes, sir, it is.
All righty. Thank you.
You're welcome.
Mr. Patricon, do you know any reason why your client should not plead guilty?
No, Your Honor.
All right. Then I'll ask you, Mr. Crane, as to the amended count 1, which charges you with possession of hydrocodone, a severity level 5 non-person drug felony, how do you plead, guilty or not guilty?
I plead guilty, Your Honor.
As to count 2, the domestic battery, which is a class B person misdemeanor, how do you plead, guilty or not guilty?
I plead guilty, Your Honor.
All right. Now, I'm going to ask Mr. Penland to tell me what he thinks the evidence would be if this case went to trial. I want you to listen closely because when he's done, I'm going to ask you if that's what happened, okay? Is that all right, Mr. Crane?
Yes, sir, sorry.
All right, that's okay. Mr. Penland.
Yes, Judge, on February 2nd of 2020, the defendant was involved in a dispute, so to speak, with his significant other, a Devin Spears. The evidence would be that they were in a dating relationship at the time, and he struck her in a way that the evidence would show was rude, insulting, or at least in an angry manner. Because of that, the police were called. They came out to the scene, which was at 8115 State Avenue, which is here in Wyandotte County, Kansas. They made contact with the defendant. They placed him under arrest, and a search incident to arrest revealed that on his person he had a number of pills of what was later determined to be oxycodone that was field tested, and it came back with the positive presumption of oxycodone.
All right. And I assume he did not have a prescription for those.
That's right.
All right. Mr. Crane, is that what happened?
Yes, sir, to the best
All
of my
right.
knowledge.
I will find that the defendant has freely, voluntarily, and intelligently entered into this plea of guilty. He understands the charges against him and the consequences of the plea. The state has provided a sufficient factual basis for a finding of guilt, and I will specifically find that Mr. Crane is guilty of the amended count 1, the possession of hydrocodone, and count 2, domestic battery. I'm going to order a pre-sentence investigation be conducted, and we are going to continue sentencing until we get that report. I'm going to guess here. I know that I said a 9 o'clock on October 2nd. I could make this one at 10 o'clock. Mr. Patricon, would that work for you?
I am not available on October 2nd.
All right. How about the 9th, which is the next Friday?
That does work for me, Your Honor.
9 o'clock in the morning?
Yes.
And Mr. Penland, same question?
Yes, that works.
All right. That's when we're gonna set sentencing. Let's talk for a second about bond. Is Mr. Crane being held on anything else right now?
Not that I'm aware of.
Not that I'm aware of either, Your Honor.
All right. Mr. Patrick Count, what do you have in the way? I assume you have a bond motion in mind.
Yeah, Your Honor, my client on, according to the amended count that he pled to would be presumptive probation. I've spoken with him regarding the consequences if he were to fail to appear for sentencing, and he's aware that, the court and the prosecution won't be bound by the terms of the plea agreement were he to abscond. We would request an OR on this case. If in lieu of an OR, if the court isn't comfortable with that, I don't know. Same as my last case with you, Your Honor. He's been in Andrew County pretty much since the beginning, and I don't know that pretrial has spoken with him or screened him. So if the court's not comfortable with an OR, I'd request pretrial screening. Since he is presumptive probation, he's been in for quite some time now. I don't see any need to keep him in when we're thinking he's going to be probation.
All right. Mr. Penland?
Judge, I agree. I'm fine with an OR bond.
Okay, so am I. All right, I'm going to grant him an OR bond today. Mr. Crane, as your lawyer mentioned, and look, I don't doubt that you're going to show up for me. I just need to give you the warning. The state's kind of released from what recommendations they make if somebody doesn't show up or if they commit another crime while they're out on bond. So it's incumbent upon you to make sure that you're back here on October 9th, or keep in touch with Mr. Patricon if we're going to do it by Zoom, which I think we are.
Okay.
So we'll just get together on October 9th at 9 o'clock for that sentencing. I'm going to get you an OR bond, get you out of there today, okay?
Yes, sir.
Did they leave you, by any chance, did they leave you a pen and paper or anything like that right there?
They did not, but
All right.
I can use one. The sheriff said, the
All right.
officer said. I was gonna say I don't want to be rude, but I was gonna see if I could ask a question.
Sure, go right ahead.
I'm sorry. This is kind of new to me. I've never been in front of a screen in court, but
Right.
I was gonna say when we do have sentencing, I'm positive I'll be there. Of course, I know the penalty of not being there. How would it work if we're gonna do it by Zoom? Do I come back up here and go through Zoom?
You could come to my office if
Okay.
you don't have the capability. Otherwise, if you do have the ability on your phone or a computer, we can forward the link to you. But otherwise, you can come to my office and we'll just sit in my office together.
Yeah, the only reason I'm saying is because my phone is kind of outdated. I don't think
Sure.
it would do it, and I could go to the library, but I don't think it would work there. So
Right. Yeah. No, keep in touch with Mr. Patricon. Look, if it's not something you're going to be able to do, then we can bring you in and make it a in-person hearing. But if you can go to his office and do that, it's probably best. The reason I was going to get you that pen and paper is to write down a phone number, but I see at the end of the pre-sentence at the end of the plea petition, Mr. Patricon already went over this request for PSI. So here's what's going to happen. Sometime in the next week or two, somebody from probation is going to be assigned to write your pre-sentence investigation, and they need to interview you for that. So they're going to use that information on that document to reach out and get a hold of you.
okay,
It's real important that you respond to that, because we can't go forward and get your sentence going, get you on probation so you can get done with it until we do that sentencing. So make sure you get with them to do that interview, okay?
okay. I was gonna say if somehow I missed their call, is there any way that I can call them back? Like, can you give me a number that I can call?
Sure. Yeah. The number there is 913
One second. I'm sorry.
573. Oh,
I'm sorry. I just.
it's quite all right.
You're right. Yeah, he's ready to go. I'm sorry about that.
913 573 2846.
2846. Yes, sir, Your Honor. Thank you very much. I'm sorry to interrupt you.
You don't need to keep apologizing. Look, somebody wants to know what's going on. I'd rather have that than us hang up and then you have something you didn't know you were supposed to do, okay?
Of course.
So you don't have to worry about asking questions, things like that. I actually think it's a good thing. All
I've
right.
just always been respectful, so I'm trying to be.
Well, you are being, that's for sure. All right. Other things for our record today?
Not from the state.
Just one thing, a matter of procedure, I guess. I don't think we ever officially waived preliminary hearing.
Ah,
So
I didn't realize that. We better do that.
I didn't think about it till just now, and so my client does waive preliminary hearing.
All
So does
right.
the state.
Okay, I'll find both parties waive preliminary hearing. All righty, thank you, Mr. Patrick, for
Thank you.
reminding me. All right, we are adjourned.